Hey guys, so we now go to Rule 111 or the prosecution of civil action. So, civil liability arising from criminal offense is generally has two aspects. The first is the civil and the second is the criminal. Under Article 100 of the Revised Penal Code, every person criminally liable for a felony is also civilly liable. The civil liability arising from a crime is known as civil liability ex delicto. So, the rationale under this rule is that the traditional theory that when a person commits a crime, he offends two entities. One is the society in which he lives, or the political entity called the state, whose law he has violated. And second is the individual member of that society, whose person, right, honor, chastity, or property was actually or directly injured or damaged by the same punishable act or omission. So, what are the exceptions here? In the instances when no actual damage results from an offense, such as espionage, violation of neutrality, flight to an enemy country, or crimes against popular representation. Sorry. Okay. So, what is the implied institution of the civil action with the criminal action? The rule is that the civil action arising from the criminal offense is deemed instituted with the criminal action. This pertains to the civil liability, as we said a while ago, ex delicto. When a criminal action is instituted, the civil action for recovery of the civil liability arising from the offense charge shall be deemed instituted. The reason for the implied institution of the criminal action is the principle that every person criminally liable for a felony, paulit-ulit, is civilly liable. A separate civil action would only prove to be costly, burdensome, and time-consuming for both parties and further delay the final disposition of the case. The multiplicity of suits must be avoided. Criminal aspect and civil aspect have different purposes. The prime purpose of the criminal action is to punish the offender in order to deter him and others from committing the same offense, to isolate him from society, reform and rehabilitate him, or in general, to maintain social order. On the other hand, the sole purpose of the civil action is for the resolution, reparation, or indemnification of the private offended party for the damage or injury sustained by reason of the delictual or felonious act of the accused. The judgment of a conviction includes a judgment on the civil liability. Because of the rule that civil action is impliedly instituted with the criminal action, the trial court should, in any case of conviction, state the civil liability or damages caused by the wrongful act or omission to be recovered from the accused by the offended party if there is any, and if the filing to the civil action has not been reserved previously, instituted, or waived. The civil aspect of the judgment of acquittal may be appealed by the offended party, the real parties in interest, in the civil aspect of a decision, or the offended party and the accused. Hence, either the offended party or the accused may appeal the civil aspect of the judgment despite the acquittal of the accused, and the public prosecutor, meanwhile, has no interest in appealing the civil aspect of a decision acquitting the accused. Kasi nga, yung parties here is the offended party only and the accused. So the rules in criminal procedure still primarily applies in the civil aspect. One of the issues being the civil liability of the accused arising from the crime. The governing rules is the rules on criminal procedure, not the rules on civil procedure, which pertains to the civil action arising from the initiatory pleading that gives rise to the suit. What if the civil aspect was separately brought either prior to the substitution or subsequent or to the criminal action? Will the rules on criminal procedure still govern, especially in relation to rules on jurisdiction and venue? So the answer is yes. So, what are the exceptions to the rule? There is no implied institution of the civil action to recover civil liability arising from the offense charge in the following cases. First is when the offended party either waives the civil action, reserves the right to institute it separately. So if the offended party decides to reserve the right to institute the civil action after the criminal action has been instituted, the reservation shall be made before the prosecution starts presenting its evidence. The reservation is to be made under circumstances that would afford the offended party a reasonable opportunity to make such reservation. There is no reservation in the cases that the civil aspect must be resolved with the criminal action. So, for example, in Batasang Pambansa 22 or BP 22 cases, the criminal action for violation of BP 22 shall be deemed to include the corresponding civil action. The right to reserve the civil action does not apply to a prosecution of a criminal action for violation of BP 22 or the Bausin Checks law. However, BP 22 does not prohibit the waiver of the civil action or the institution of the civil action prior to the criminal action. And cases naman under Anti-Graft and Corruption Practices or RA 3019, pending before the Sandigan Bayan, is also an exception. So we need to institute it prior to the criminal action. Then, in cases of independent civil action, we um we go to Rule 111, Section 3. So we go now to counterclaim, cross-claim, and third-party claim in a criminal action. So note that counterclaims, cross-claims, and third-party claims will be studied in civil procedure. So more on this on civil procedure next semester. So the rule is that no counterclaim, cross-claim, or third-party complaint may be filed by the accused in a criminal case, but any cause of action which could have been the subject thereof may be litigated in a separate civil action. A court cannot entertain counterclaims, cross-claims, and third-party complaints in a criminal action. A criminal case is not the proper proceedings to determine the private complaint's civil liability. A court trying a criminal case is limited to determining the guilt of the accused and, if proper, to determine his civil liability. It cannot award damages in favor of the accused. So, how about filing the fees for criminal actions? I-discuss din to more on civil procedure, but there are no filing fees required for actual damages claim, except when otherwise required by the rules. So we go now to when the separate civil action is suspended. So the rule here is that after the criminal action is commenced, we observe the following. First, if the offended party reserves his right to institute it separately from the criminal action, the separate civil action cannot be instituted until the final judgment has been entered in the criminal action. Second, if instituted prior to the criminal action, the separate civil action shall be suspended in whatever stage it may be found before judgment on the merits once the criminal action is filed. So the rule indicates that preference is given to the resolution of the criminal action. So what happens to the prescriptive period of the civil aspect during the pendency of the criminal action? The running of the period of prescription of the civil action, which cannot be instituted separately or whose proceeding has been suspended, shall be toiled. So this rule does not apply to separate and independent civil actions under Section 3 of Rule 111. Independent civil actions are separate and distinct from the criminal action. It proceeds independently regardless of the result of the latter. This is also discussed in torts and damages. So we go now to the independent civil actions. So independent actions are different from those reserved or instituted prior to the criminal action. The latter is for the enforcement of the civil liability ex delicto, while the former is based on law or quasi-delict. Sabi ko nga, diniscuss ko in torts. Only the civil liability ex delicto is deemed impliedly instituted with a criminal action. So when can a civil action proceed independently? In cases provided by law, the independent civil action may be brought by the offended party when it shall be when it shall proceed independently of the criminal action. So here are the cases. So when the law provides an independent civil actions, it pertains to Article 32, 33, 34, and 31 of and 2176 of the Civil Code. So Article 32 pertains to violation of constitutional rights, 33 pertains to defamation, fraud, and physical injuries, 34 pertains to failure to aid by police, and Article 31 and Article 2176, as we know from our torts, pertains to quasi-delicts. So under the rules, only the civil liability of the accused arising from the crime charged is deemed included in a criminal action. Thus, the civil actions referred to in Articles 31, 32, 33, 34, and 2176 of the Civil Code shall remain separate, distinct, and independent of any criminal prosecution which may be based on the same act. Thus, unlike a separate action for the civil liability ex delicto, which requires a reservation, there is no need to reserve an independent civil action. This is because while the liability arises from the same act, it does not arise from the same source. The civil liability in the rules refers to those arising from delict, while the civil liability, which proceeds independently under the Civil Code, arises from direct provisions of the law. The civil actions arising from 32, 33, 34, and 2176 of the Civil Code may be filed independently and separately from the criminal actions. Kasi nga, they do not arise from the same offense charge. But in no case, however, may the offended party recover damages twice for the same act or omission charged in the same criminal action. This is provided for in Article 2177 of the Civil Code. So, what are the consequences of the independent character of actions under 31, 32, 33, 34, and 2176 of the Civil Code? We have around six. So, first is the right to bring the civil action shall proceed independently of this criminal action and regardless of the results of the latter. Second, the quantum of evidence required is preponderance of evidence. Third, the right to bring the foregoing actions based on the civil code need not be reserved in the criminal prosecution since they are not deemed included therein. Fourth, the institution of the waiver of the right to file a separate civil action arising from the crime charge does not extinguish the right to bring an independent civil action. Fifth, even if a civil action is filed separately, the ex delicto liability in the criminal prosecution remains, and the offended party may, subject to the control of the prosecutor, still intervene in the criminal action in order to protect the remaining civil interest therein. And lastly, the rules on suspension and consolidation in Section 2 does not apply in independent civil actions. So we go to the effect of extinction of the criminal liability on the civil liability ex delicto. So when criminal liability is extinguished, we go to Article 89 of the Revised Penal Code. How about the effect of extinction of the criminal liability by reason of the acquittal of the accused? So the acquittal of the accused does not carry with it extinction of the civil liability. In case of his acquittal, the accused may still be adjudged to be civilly liable, in which case proof beyond reasonable doubt is not required, but mere preponderance of evidence. So criminal liability is harder to prove than civil liability because the former demands proof beyond reasonable doubt, while the other, preponderance of evidence lang. Now, that criminal conviction is not obtained because of reasonable doubt, there is still chance na yung civil liability can be held to exist because meron pa rin siyang preponderance of evidence. Such in the cases when, one, the acquittal is based on reasonable doubt, so pwede pa rin civilly liable siya. Two, the acquittal is based on justifying or exempting circumstances where civil liability survives. And third, the civil liability of the accused does not arise from or is not based upon the crime of which the accused was acquitted. So the exception is when the civil action is based on delict shall be deemed extinguished if there is a finding in final judgment in the criminal action that the act or omission from which the civil liability may arise did not exist. If, in a criminal case, for example, the accused is acquitted because the fact from which any civil liability could arise did not exist, a civil case subsequently brought must be dismissed. This is not a mere case of acquittal because of reasonable doubt. There are two kinds of acquittal recognized by our law with different effects on civil liability. So first, we go to acquittal on the ground that the accused is not the author or of the act or omission complete of. In this instance, it closes the door to civil liability for a person who has not been found to be not the perpetrator of any act or omission cannot be held liable for such act or omission. There being no delict, civil liability ex delito is out of the question, and if civil action, if any, which may be instituted, must be based on the grounds other than that delict complained of. This is the situation contemplated under Rule 111. So second naman daw is the acquittal based on reasonable doubt on the guilt of the accused. In this case, even if the guilt of the accused has not been satisfactorily established, he is not exempt from civil liability, which may be proved by preponderance of evidence only. This is the situation contemplated in Article 29 of the Civil Code. So, what is the effect of the extinction of the criminal liability by reason of death of the accused? So, if the accused dies before arraignment, the case shall be dismissed, but the offended party may file the proper civil action against the estate or legal representative of the deceased. if the accused dies after arraignment, but before judgment of conviction becomes final, pending judgment or appeal of the criminal action, both the criminal liability and civil liability ex delicto are extinguished, since the criminal action is extinguished inasmuch as there is no longer a defendant to stand as the accused. The civil action instituted therein for recovery of civil liability ex delicto is ipso facto extinguished, grounded as it is on the criminal case. It is clear that the death of the accused pending appeal of his conviction extinguishes his criminal liability, as well as the civil liability ex delicto. The rationale, therefore, is that the criminal action is extinguished inasmuch as there is no longer a defendant to stand. Kagaya ng sinabi natin kanina. The civil liability from independent civil actions and from other sources of obligation may be brought or continued against the estate or legal representative of the accused. So what if the accused dies after judgment of conviction becomes final? So the judgment of the civil liability ex delicto is enforced as an ordinary money claim against the estate. So what if there is already final conviction, but the civil liability ex delicto was reserved and subsequently instituted only after such final conviction and the accused dies? So the action survives and it may be continued against the heirs of the deceased under the rules of substitution. The civil liability ex delicto survives in this case. As the criminal liability has already been settled, there is no more issue on the criminal liability. So we go to the effect of novation on the criminal liability. So the rule is that novation is not one of the grounds prescribed by the RPC for the extinguishment of criminal liability. In a content of cases, it was ruled that criminal liability for estafa is not affected by a compromise or novation of contract. In the crime of estafa, reimbursement or belated payment to the offended party of the money swindled by the accused does not extinguish the criminal liability of the latter. Criminal liability for estafa is not affected by compromise or novation of the contract, for it is a public offense which must be prosecuted and punished by the government on its own motion, even though complete reparation should have been made of the damage suffered by the offended party. Thus, the doctrine that evolved from the aforementioned cases is that a compromise or settlement entered into after the commission of the crime does not extinguish the accused liability. So, yun na nga, sinasabi na dito sa novation, it does not really extinguish the accused's liability. So we go now to, umulit yung slide. We go to the effect of extinction of civil liability on the criminal liability. So the rule is that the extinction of civil liability itself does not extinguish criminal liability, such as if the civil liability is extinguished by reason of 1. Absolution of the accused in a separate civil action, 2. Compromise between the offended party and the accused on the civil aspect. Oh yeah. And lastly, the effect of acquittal of the accused in an administrative case. The acquittal of an accused who is also a respondent in an administrative case does not conclude the administrative proceedings, nor carry with it the relief from administrative liability. This is because, unlike in criminal cases, where the threshold quantum of evidence required is proof beyond reasonable doubt, only substantial evidence is necessary in administrative cases. So a prejudicial question, nilagay ko sa screen, is an issue involved in a civil case which is similar or intimately related to the issue raised in a criminal action, the resolution of which determines whether or not the criminal action may proceed. To be a prejudicial question, it presupposes that the civil action must be instituted previously or ahead of the criminal action. So it is that which arises in a case, the resolution of which is a logical antecedent of the issue involved in that case. So what is the effect of the existence of a prejudicial question? It suspends the criminal action pending the resolution of the civil action. The action to be suspended is the criminal action and not the previously instituted civil action. The criminal action may be suspended pending the final determining of the issues in the civil case. A prejudicial question accords a civil case a preferential treatment and constitutes an exception to the general rule that the civil action shall be suspended when the criminal action is instituted. So yun lang naman yung mga kailangan natin tandaan dito sa Rule 111. It's mostly independent civil actions na kailan ba yung ex delicto, kailan ba siya mag-a-apply na independently of the crime. So these are the things we should remember in Rule 111. So thank you for listening again. Don't forget to hit like and subscribe. Good luck!